In high income and high asset divorces and custody matters, there's special care that must be taken to make sure that you protect the children. We've done that for almost 20 years now. One of the things that's really important to do is to have an agreement between the parties that incorporates everything that protects the children. Meaning, if the children have nannies, if the children have au pairs, if the children have certain schools and extracurricular activities that they go to and participate in, we make sure that that's protected in the orders concerning the kids so that the children receive the least amount of harm from parents separating. When we're deciding custody agreements for high net worth or high asset individuals, we take into consideration all of the child's needs and we try to be as clear and explicit as possible for as long of a time as we can so that it's put in the order and there's no confusion as to what's supposed to happen. So if we're supposed to send the child to this private school, have this nanny work with the child, or these teachers work with the child for, after school help, we put that in there so that anybody that's helping assist the child, which many times will be more than the high asset individuals, they know what to do with the child so that it's the least disruptive to the child as possible. I would say some of the main differences when you create a parenting plan for a public figure or a celebrity is that you create a plan recognizing that more than just the parents will be involved. It will involve additional people, nannies, au pairs, other family members, babysitters, etc. Because many times public officials or high net worth individuals are not singularly parenting their children. They're having additional people come help with caregiving, and that needs to be expressed in the agreement so there's no misunderstanding when the child is going or the children are going back and forth between parties as to who's supposed to be consistent to make sure that the children's lives are as consistent as possible. Most courts consider mediation as mandatory before you have a temporary or a final hearing on a divorce or a custody case, because many times the parties can work out these matters before a judge has to come and rule on these matters. And so because courts have started using ADR, alternative dispute resolution, practices such as mediation, it's best to understand what mediation is and go to it so that hopefully your case can resolve the way you want it to, because you and the other party will come up with a solution that you all both agree to and that you all sign that can be the final order of what happens in a divorce or a custody case. If the parties aren't doing what's agreed upon, then one party can file a citation for contempt. When you file that citation for contempt, that means that you think that the other party's not been doing what they're supposed to do, which is written in the order. The judge will grant a hearing, and when that hearing happens, evidence will be presented. And if the party's found in contempt, there will be sanctions up to and including jail time that you could face if you're found in contempt for willfully violating an order of the court. If you're navigating through a difficult custody situation and you're a high asset individual or a public official, please give us a call. We're here to help. We've been dealing with these situations for 20 years, and we'd love to be here for you as well.